and Fox. State ready?
State's ready.
Ms. Zachariah, are you ready?
Yes, Judge, we're ready.
All right. This is the state's motion. Ms. Zachariah, are you going to have Ms. Fox testify?
Judge, we have a couple of exhibits that we'd like to present, but unless the court would like to hear from Ms. Fox, I think that we can get most of what we need to across with her exhibits, considering her felony pending right now.
All right. So bottom line is she going to testify?
One second.
Judge, I sent you the judge's notes. I don't know if you've been able to locate them.
I did.
217, okay.
Judge, no, I don't think we're going to call Ms. Fox as a witness at this time.
All right. Then state, it's your motion. Who's going to run the show, Ms. Morgan or Mr. Edelman?
I am asking the CLO if we have the supervision officer to testify to certain facts.
I thought we were pleading true, Andrew.
Well, if she's going to plead true, then she's going to need to testify. You're saying that she's not going to testify, so she can't plead true.
Yes, we're going to plead true. Okay, yes, we're following the same.
Okay.
My apologies, Judge.
No problem. All
Okay,
right,
so
let me go back and find the notes.
you still want me to have her join?
No,
No, my apologies, Judge.
Okay.
That was a
All right,
misunderstanding.
let me tell her.
not to worry.
And I'm sorry, Miss Laura. Yes, she said it's still the same rec.
Perfect. All right.
Let me get back on the page here.
Apologies, Judge.
No problem. All right. Ms. Fox, would you please raise your right hand? Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, ma'am. You may put your hand down. Ms. Fox, I need to talk to you about a couple of things before we go any further. One, you have the right to remain silent. That means you do not have to make a statement. You don't have to answer questions. You don't have to submit paperwork, especially papers that may admit or confess to wrongdoing. You understand you have the right to remain silent?
Yes, Your Honor.
All right. When you entered a plea on or about January 14th of 2019, at that time, it was made clear to you that you did not have a right to appeal because you participated in a plea bargain. Today, you have a limited right of appeal. That means that you can appeal this particular proceeding and the results, but you cannot appeal the original plea that you made on or about January 14th, 2019 to the original charge. Is that understood?
Yes, Your Honor.
All right. Now, you also have the right to demand that this hearing be held in the open public courtroom. Because of the COVID pandemic, we have not been doing that. We've been doing these on video conference, and they are streamed on YouTube, which makes them somewhat public, but not in the sense of the constitutional and statutory right to a public trial or public hearing. Do you understand you have those rights, that's involved?
Yes, Your Honor.
All right. Are you willing to proceed on video conference instead of demanding that this be done in the courtroom?
Yes, Your Honor.
Okay. Now, your probation was assessed on January 14, 2019 for a period of 16 months. Prior to the expiration of that date, there was a motion filed to revoke your probation. That was on October the 16th, 2020. The predictable or the predicted expiration date was to be November 13th of 2020. So the filing of the motion extends this probation obligation. The offense was originally DWI second. Mr. Edelman, it was in fact, there was a probation for DWI first, is that correct?
Believe so, sir, yes.
All right. So now, what is the agreement, if any, between the state and the defense?
That Ms. Fox will plead true to violation of condition number 21. Ms. Fox will agree to the court altering and amending the conditions of her supervision to include cognitive behavioral course, continue sessions with LCDC with documentation, extend her
Okay.
super.
Wait, I'm gonna have to write all this down. As to pleading true to condition, violation of condition number 21, I need a little more information, sir. In that what?
In that she failed to comply with zero tolerance.
All right. So to that, she will plead true or not true?
I would plead true.
All right. Now, Ms. Fox, I want to make it clear that if you plead true, I am in a position as the judge to revoke your probation and declare several or some results of that. That is, including findings and sentencing and amendment of the conditions. Do you understand that?
Yes, you are.
All right. So, did anyone intimidate you or threaten you to get you to plead true?
No.
All right. Then the court finds that it is true that you violated condition number 21 as stated. Now, as a result, will I be denying this, Mr. Edelman? Is that the recommendation, and amending or what?
Deny the MTR, alter and amend conditions. Let me know when you're ready to proceed, sir.
I am right now.
Add cognitive behavioral course. Continue sessions with LCDC.
Sessions, plural?
Yes, sir. With
Right, sir.
LCDC with documentation.
All right.
Extend probation for 1 year from the initial date of expiration, not from today.
And is that it?
Ignition interlock for the full term of supervision. And hold SATIF in abeyance.
It's SATIF or FF?
SATF. Substance Abuse Treatment Facility.
I got you. All right. Is that it?
That's it from the state, sir.
Judge, we do have some stuff we'd like to present to the court in favor of the bargain.
Give me a second, please.
No
I have-
problem.
I have to correct all my typewriting errors
No problem, Judge. You let me know when you're ready.
already. Let's see. Continue sessions with LCDC with documentation, extend probation, not probation. Okay. Extend probation. Damn it. From initial date of expiration, initial act for full term. All right, Mr. Edelman, listen up.
Yes, sir.
We're gonna add cognitive behavioral course. Continue sessions with LCDC with documentation. Extend probation for 1 year from initial date of expiration. Ignition interlock for full term of supervision. Hold SATIF in abeyance. All right. I think I've got that. Now, Ms. Zachariah, what else did you want to address or?
Well, Judge, we just want to provide the court a little bit of context. And then as far as the cognitive behavioral course, Judge, we've got some documentation to provide to the court regarding her ongoing cognitive behavioral therapy that she's already engaged in. So if we could just present a couple of those to the court right now, I'm going to share the screen with you, if that's okay.
That's fine with me.
Judge. All right. Did that pull up right, Judge? And we've already presented these exhibits and been reviewed by the state, Judge.
Hold on.
And
a
the
second.
state has no objection to the defense introducing them as exhibits.
All right, hold on. I'm still on this page over here.
No problem, Judge. Let me know when you're ready.
Yes, ma'am. Am I going to add anything to the documentation, Ms. Zachariah?
Any documentation regarding what, Judge, if you could clarify?
All right. Did you see the agreement page?
Like I said, Judge, the only note that we would have regarding the agreement is that she be permitted, as far as the cognitive behavioral course, to continue her ongoing cognitive behavioral therapy that she's already engaged in, with documentation, of course,
All right.
which I have.
Is this with LCDC you're talking about?
So Judge, this first exhibit that we're presenting is that Miss Fox has already been in therapy with a licensed chemical dependency counselor since November of 2020, Judge. Based off her review, Miss Fox does suffer from severe anxiety. She scored up to a 64 on the anxiety index, Judge. And most of her drinking in the past, including her prior offenses that have led us here, have been a result of anxiety or stress-ridden life events, such as the death of her sister in 2010, and then some stress from harassment and stalking in 2016, Judge. So she's very much been reactive to stressful situations in her life. And the reason that we're advocating for this continued therapy, Judge, is that it's been successful for her, Judge. She's been very successful in the treatment. It's been helping her. The incident in question here regarding the violation of zero tolerance is Miss Fox did consume some alcohol on the date in question, Judge. As a result, of that consumption, she had recently lost her job, Judge. She had lost her insurance and her ongoing treatment for ongoing medical disorders that she had. So based off that stressor, she did consume alcohol that day. And she was honest with her probation officer regarding that, Judge, as well. And she's done everything she can to correct that error, including going to continued therapy. Can I scroll down, Judge?
Yes, please.
Okay. As you can see, she's already got a treatment recommendation plan. She's going to continue seeing her licensed chemical dependency counselor to work on these goals and assessments. So we just, again, urge that you allow her to continue with the therapy she's already been engaged in since this motion to revoke was filed.
All right.
And then as far as the cognitive therapy, Judge, this is the cognitive therapist that she's been seeing and successfully being treated by since November of 2020 at Camino Real Community Services. We'd ask that as a portion of your order, amending her conditions, that she be allowed to continue this treatment program in lieu of that cognitive therapy course, that this be what she be ordered to continue in, which is a cognitive behavioral therapy and skills training development course.
All right. Is this incorporated already in what you dictated, Mr. Edelman?
I believe so, sir.
That was my impression.
I just want to make sure that it's clarified for probation that this is the course that she's going to continue in, Judge, and that it's not like an additional course or anything like that was just the concern. And then there are a couple of letters of recommendation, Judge, since it's agreed. I'm not sure if you want to read through those or not.
I don't think we need that. You're an officer of the court and you've made a good presentation.
Perfect, Judge.
I just need to just add a little bit of language on the paperwork that I have here.
Before I close out, Judge, I just want to emphasize that Ms. Fox has made a huge turnaround in her life. She's got a new job, which she's doing great in, and she's got full insurance now. She's being treated for all of her health stuff, and she's doing really good. She's been attending consistent AA meetings weekly since November as well, and she's been really making a change in her life, and she hopes that you'll consider this and
Was this something that she did totally on her own, or did you work with her on this, or somebody else
She did
encouraged her?
a lot of it. As far as the cognitive behavioral therapy, Judge, she did that all on her own. She was in the midst of a pretty severe custody battle that was taking a big toll on her mentally. So her family actually helped her getting into some therapy programs. As far as the LCDC, that was at the recommendation of our firm that she go see an LCDC after picking up her new charges. And she appreciated that so much that she continued on her own to go see the LCDC. And the AA meetings were a recommendation as a portion of that dependency counseling, which she continued again on her own volition. A lot of this has been definitely her, Judge. She's had a little nudges from her community support, but she's really been making a difference. And I know we're extremely grateful to have her as a client. So,
Well, let me bring up the documents again so I can finish my work on that. This damn thing kills me. Every time I go one way or the other, it makes me put in my password again.
hopefully we're almost done with this virtual stuff, Judge.
I don't know that we are, to be honest with you, because the Supreme Court and the Office of Court Administration are still encouraging us to do as much as we can virtually.
Yeah. Well,
So
hopefully
we
one
might-
day we'll get back to normal. One of these days.
Okay. All right, add cognitive behavioral course as a court requirement, noting that the defendant, or I should say Ms. Fox, is to continue on her current plan system, what?
It is a development course. It's a cognitive behavioral therapy and skills training development course with Camino Real Community Services.
You'll forgive me if I don't pronounce it like you. It's Camino Real.
Oh, I'm
With
sorry.
Camino Real, what?
Community Services, Judge. Oh, that's close.
Looks like I'm gonna have to just leave it like that because I ran out of space in this thing for whatever reason. With Camino Real, I'll leave it there. All right, now, other notes.
That was it from our side, Judge. She's
Oh, no, this is from my side.
Okay.
What's the name of your firm?
Holscher Gebbia Cepeda, Judge.
I'm sorry,
Holscher Gebbia Cepeda, Judge.
I'm missing the first one.
Holscher, Joseph Holscher,
Holscher.
HOELSCHER.
Holscher,
Gebbia, Robert Gebbia, Judge, GEBBIA. And then Cepeda, spelled
the
normal.
C or Z?
C, as in
C,
cat. C is in cat, Judge. PLLC.
all right, under other notes, I am adding the court salutes the Holscher Gebbia Cepeda firm, particularly Ms. Zachariah, for helping their client and dealing not only with the defendant as client, but with defendant as a person. I'm impressed that y'all guided her. That's why I asked. Guided her the way you did. I am pleased that y'all are looking to help people, not just represent them and make money.
First Judge.
And that's part of my file. It'll be part of what I'm saying in the record. Ms. Fox, I consider you fortunate that that you've had what I consider is real, not only representation but consideration and help. So that's it for me. Any questions, Ms. Fox?
No, Judge. Thank you.
I hope you continue to do well and get yourself totally under control and you don't face this kind of troubles anymore, or if you do, that you're able to handle them properly. Ms. Zachariah, again, thank you. Any questions, Mr. Edelman?
Nothing from the state, sir.
All righty. Then this will complete this